going to be a quickie. I just wanted to clarify something about piracy and copyright. First of all, in case you don't know, copying is not theft, because theft implies you're taking something from someone. That's why they call it piracy, because they can't legally call it theft or stealing, because it's not stealing. What you're doing is you're violating the exclusive right of distribution. That's what copyright is. Excuse me, I got a little bit of a stomach thing going. But copyright is an exclusive right of distribution for the people who own the intellectual property. So to violate copyright, you have to be basically making copies of the material and distributing it. If you just make copies of the material, I mean, technically that's part of copyright too, implicitly, if I recall correctly, but the real violation of copyright is in distribution. Receiving a work that someone else copied is not a violation of copyright law. You buying a bootleg or whatever, that's on the person who distributed it. And that's kind of the clarifying point I want to make. I'm aware that in court they managed to get away with people who maybe shared some files with trying to charge them with all the files they found, like not charge them, but in a lawsuit, say that, oh, you violated copyright for all these things, when they weren't necessarily even sharing them. There's not necessarily any proof. And the big thing that really bothers me is torrents and magnet links, because if you get a torrent or a magnet link, neither of those contain any copyrighted material at all. In fact, a torrent is literally a list of file paths and hashes and server names. I mean, there's some nuance to it. There might be extra information, but at its core, it's really just here's signature information and names of files, and here's a server. You might be able to find other people that might have those files, or you might find no one. So torrents and magnet links, especially, in my view, now I'm not a lawyer, and I'm sure some lawyers have been educated out of thinking this way, but if you're distributing something that tells you about a digital copy of a copyrighted work, I'm pretty sure that's not copyright infringement. Now, if someone takes that and uses that to obtain a copyrighted work, maybe that's different, but even then, I think it's still not. Under the law, ideally, based on what I've read in the law, the copyright is the right of distribution, and if you're requesting that someone give you a copy of something, it's on the person giving the copy, not the person receiving. The snag with file sharing networks is, unless you're leeching, which means you're not uploading anything back at all, you're not contributing to the peer-to-peer networking, unless you're 100% leeching, you can be said to also have distributed it. Of course, the threshold should be higher. Like, can you prove that I distributed any of this? Probably not. They'd have to request it, and it gets murky from there. But I just wanted to clarify that little nugget, because I feel like that goes under the radar. People always talk about copyright lawsuits, and they never cover that. It's always just implied, and usually it's the fact that people did upload because that's what their clients do that caused them to get in trouble, that caused it to stick. So, my 2 cents. Have a good one.